So thank you all for joining me today for our webinar, Counsellors, Confidentiality and Courts. Just to introduce myself, I am an Associate Solicitor with Michael Lynch Family Lawyers. I've been with Michael now for about 4 years, and I've been working exclusively in family law for approximately 13 years or so now, in both Melbourne and Brisbane. So very briefly, for those of you who are not familiar with Michael Lynch, we are a specialist family law firm and we do nothing else. We are in our 23rd year of practice. We have approximately 11 solicitors and 5 of them are accredited family law specialists. We provide clients with advice in relation to a range of family law matters, and we can assist with negotiation, mediation, and if necessary, court representation. If clients do need legal advice, please bear in mind our fixed fee for our initial consultation. And you may already be a subscriber to our newsletter, and if not, please do not hesitate to contact us and add your address to our mailing list. So in terms of the presentation today, the aim is really to give you an overview of the family law principles and processes, and then to focus particularly on where you, as counsellors, may fit into those processes. So the topics we'll talk through today are the principles of the Family Law Act, particularly as they relate to parenting matters, the resolution processes that people can undertake to reach an agreement, and how those agreements can be documented, as well as looking at the court processes as it applies to parenting, and then relevantly how you fit into those processes. When we talk about how you as counsellors fit, and possibly family dispute resolution practitioners, my apologies, fit into the processes, we'll be talking about any advice obligations, notification obligations, confidentiality and admissibility sessions and family dispute resolution processes as well, subpoenas, and voluntarily providing affidavits or reports for the court or your client. The main applicable law in family law, as many of you may know, is the Family Law Act 1975, which is Commonwealth legislation, and it applies in all states and territories of Australia except Western Australia. It deals with all matters related to divorce, property settlement, both following the breakdown of a marriage, breakdown of a de facto relationship, and issues relating to parenting arrangements following separation. So when I talk about the Act today, I'm referring to the Family Law Act. And there have been many amendments to the Act since 1975, as you can imagine, and the most recent ones were enacted in 2012, and they relate to the family violence provisions of the Act. The courts which exercise family law jurisdiction are both the Family Court of Australia and the Federal Circuit Court of Australia. And some of you may be aware that the proposal by the federal government to merge the two courts is still unresolved. So interesting times ahead for all of us. Magistrates' courts in each state except WA also have some limited jurisdiction in relation to particularly approving consent orders following agreement being reached by parents. So let's begin by looking at the principles of the Act so far as they relate to parenting matters. The most important thing to know, and I'm sure many of you already know, that it's the child's best interests which are the paramount consideration for the court when considering parenting matters. It's also important for, where appropriate, usually both parents to have a high level of meaningful involvement in their children's lives, and that's certainly the aim of the legislation. Ideally, parents should try and reach agreement between themselves about parenting arrangements rather than relying on the court processes to determine those for them. Following separation, the two main parenting issues that parents need to reach agreement about or request that the court do so are parental responsibility and living arrangements. So let's discuss each of these now. Parental responsibility is defined in the Act as all rights, powers and duties that parents have in relation to their children. The responsibilities relate to both decisions about day-to-day decisions and major long-term decisions and issues. Day-to-day issues are things like what time the children go to bed, who can care for them, what are you packing their school lunches, those sort of really mundane day-to-day issues. And there's no need for any input by the other parent in relation to those day-to-day issues. Major long-term issues is defined in the legislation, and they relate to things like children's long-term health decisions, education, change to their name, and changes to their living arrangements, which makes it harder for the children to spend time with the other parent. The Act provides that when a court makes an order, whether making a determination of their own volition or approving agreement made between the parents, which we'll talk through shortly, the court must apply the presumption that it's in the best interest of the children for the parents to have equal shared parental responsibility. An order for equal shared parental responsibility means that the parents must consult with each other and make a genuine effort to come to a joint decision in relation to those major long-term issues: education, health, changes of name, changes of living arrangements. That presumption does not apply in circumstances of family violence, and it can be rebutted on those grounds or on the basis that it may not be in the children's best interest for the parents to have equal shared parental responsibility. The alternative to equal shared parental responsibility is sole parental responsibility, and it may be that one parent has sole parental responsibility in relation to one or more of those major long-term issues. So it may be that one parent has sole parental responsibility for health decisions. The flow-on effect, as detailed in the slide, for a child's living arrangements of how parental responsibility is exercised is that if parents have equal shared parental responsibility, then the first type of living arrangement that the court must consider is an equal time arrangement with both parents. However, such an arrangement will only occur where it is in the best interest of the particular child and if it is reasonably practicable. If it is not in the children or child's best interests, nor is it reasonably practicable, then the next arrangement the court must consider is substantial and significant time. And in my experience, that is the arrangement that is occurring in most separated families. So what that means is that the children live primarily with one parent and spend time with the other parent. And substantial and significant, what does that mean? In reality, we find it means time on weekends, during the week, school holidays, and of course special occasions and special days to that particular family and child. And the aim of that is to allow the children to be involved in the day-to-day life of the other parent and vice versa, the parent being involved in the day-to-day experiences of the child or children. Again, substantial and significant time would only be ordered or apply where it is in the best interest of the child to do so and it's reasonably practical. So when I say reasonably practicable, essentially what we're talking about is, do the parents live close enough to the child's school for both parents to facilitate getting that child to school, and should one of the children leave their runners at the other parent's house, facilitating delivery of the runners to school. Okay, so let's turn to determining best interests of the child. The child's best interests are and should always be the most important consideration for the court and for parents when trying to reach an agreement regarding care arrangements. The Act specifically in section 60cc sets out the considerations when determining best interests, and there are both primary considerations and additional considerations. Primary considerations are the benefits to the child of having a meaningful relationship with both parents and the need to protect the child from psychological or physical harm and from being exposed to abuse, neglect, or family violence. The Act specifically says that if there is a conflict between those primary considerations, the need to protect the child takes precedence. Section 60cc sets out 13 additional considerations that the court must take into account when determining a child's best interests. And these include things like a child's wishes or views, depending on the age of the child, the capacity for each parent to provide care for the child, the extent to which each parent has taken up the opportunity to be involved in the child's life, and each parent's attitude towards the responsibilities of parenthood. So these considerations essentially say that if there is something relevant to that child when determining their best interest, it should be considered. So having looked at the principles of the Act, now let's talk through the resolution processes. Bearing in mind the principles of the Act, hopefully parents will get to a point where they have an agreement in place regarding those decisions regarding parental responsibility and living arrangements. The first means of reaching an agreement is by direct negotiations, and obviously that's the ideal outcome. Keep us out of it. If that doesn't work, sometimes people will come and see us or other solicitors and get advice which will hopefully assist them to continue to negotiate with the other parent. Family Dispute Resolution, or FDR, is mandated by the legislation as being mediation in parenting matters, and that's there to assist and encourage parents to come to an agreement between themselves in relation to those arrangements. FDR is required by the Act prior to making any application to the court seeking parenting orders, unless, of course, there are circumstances of family violence or urgency. And if none of those processes are successful, then as a last resort, one parent may need to consider a court application. If the parents are able to come to an agreement, one of the processes, after one of those processes that we've just discussed, there's 3 options to document that agreement. The first is to keep the arrangements essentially informal, and many families feel that this is a good option for them, particularly where there's a level of trust between the parents. If the parents want to come to an arrangement that is more formal and reduce that agreement to writing, there are 2 options. One's a parenting plan and the other is consent orders, and we'll look at both. A parenting plan is essentially a written agreement that sets out the arrangements for the children. It can be quite detailed in terms of, for example, what happens during school holidays and on other special occasions, and it can also include the arrangements for facilitating the children to extracurricular activities. And in order for it to be a valid parenting plan, the agreement must be signed and dated by both parties, and it must be entered by both parties free from any pressure or duress from the other party. The benefit of a parenting plan is that it's quite flexible, but the downside is that it's not strictly a legally binding document. That is, if a parent breaches a term of that parenting plan, there's no means to enforce of itself the terms of that parenting plan. But should the matter come before the court at some later stage, the court must have regard to the terms of the parenting plan, and usually the parent who has breached a term of that parenting plan must provide an explanation for that breach. The other means of formalising the agreement between parents, which is legally binding, is consent orders. Essentially, that is an agreement between the parents about parenting arrangements, which is reduced to writing, signed by the parties and submitted to the court for review. If the court is happy with the orders that the parents are seeking, it will then make those orders, and then those orders become binding and enforceable on the parties. So once made, parents can be punished for failing to comply with orders, and a variety of different contravention remedies are available to the court following the court deciding on the seriousness of the contravention. It is important to know that if parents enter into a parenting plan after orders have been made by the court, whether that's the court making a decision of its own volition or having approved consent orders, the terms of the subsequently entered parenting plan override the terms of the order where they conflict, even though the parenting plan document of itself is not enforceable. In terms of family dispute resolution and that process, that's the process by which a practitioner, a family dispute resolution practitioner, conducts a conference or mediation to assist parties resolve issues relating to parenting arrangements following their separation. A family dispute resolution practitioner must be accredited under Section 10 G of the Act, And generally that means by complying with the accreditation rules, completing the appropriate course and undertaking some supervised sessions with a qualified FDR practitioner and then becoming accredited. As mentioned moments ago, FDR is mandated by the Act prior to making a court application, unless one of the exemptions of urgency or family violence apply. Now, in terms of court proceedings, the process begins with an application which one parent or party files, that is, submits to the court registry. And in that application, they seek particular orders be made in relation to the children. That application is supported by an affidavit from that party or other relevant witnesses, and that sets out the evidence upon which they base their request for orders to be made in their favour, which are outlined in their application. The other mandatory document required is a notice of risk, which identifies the risk of harm or likely risk of harm to a child involved in that application. And both the applicant and the respondent must complete and file a notice of risk. The other party is served with the application and the supporting documents, the affidavit and notice of risk, and should respond by filing a response setting out the orders they seek the court make. And they will support this with an affidavit by them and other relevant witnesses. The matter then comes before the court, and that's in a first court event, which we refer to as the first return date. And at that first court date, the court really wants to know what the case is about, what further steps need to be implemented to progress the matter towards resolution. And that may be that there needs to be some independent evidence obtained, or there may need to be some interim orders made in relation to the children spending time pending a final outcome. In almost all cases, the court will order the preparation of a family report. A family report, as many of you may know, is an assessment by a social worker or psychologist who has experience in dealing with family law parenting matters. And the report writer will undertake an assessment of the family for the process of providing either a long report or a shorter memo form of a report. And that assessment involves interviewing the children and each of the parents and any other significant adults in the child's life. That may also be interviewing the child or children, depending on their age, and they'll also read all of the documents that the parties have submitted to the court and any subpoenaed documents which have been obtained, which may include notes from counsellors, psychologists, etc. The court also has power to appoint an independent children's lawyer, or ICL, and that's a separate representative for the child or children. Their role is to advocate for the child's best interests rather than doing essentially what the child wants them to do. The ICLs do not take direct instructions from the children. They're usually funded by legal aid, so they're separately funded to the parents. ICLs tend to be appointed in cases which involve substance abuse issues, mental health issues, international relocation, so the more difficult matters, and where a parent or both parties are not legally represented. Now, the other stages of the process in terms of court proceedings, I really wanted to talk through were both the interim and the final hearings, and it's probably easier to talk about the final hearing first. That's really the court process that all the other court processes are working towards, and that's where all the witnesses will provide their evidence and be cross-examined or tested in relation to their evidence. The lawyers will make submissions to the judge, and the judge will ultimately make a decision. And that's the only opportunity that the court really has to test the evidence of each of the parents and other people who have provided evidence to the court. So by contrast, the interim hearing is a hearing along the way, somewhere along the way, and it may be that there's a number of those interim hearings before you get to a final hearing. At an interim hearing, there's no cross-examination of the witnesses, so independent evidence such as a family report or from psychologists or counsellors, it can be quite crucial, as at that stage the court has no way of testing each parent's evidence, as often they're quite conflicting. So yes, that independent evidence by way of a family report or report from counsellors being produced is quite important at that stage. So that's the process of court proceedings, and really it is very much a process. Currently, there's less than 10% of matters which require a final hearing, even though they may have been initiated in the court system. So that's because a lot of the matters essentially resolve or agreement is reached somewhere along that way. And a lot of the time that's after the parties have received a family report, as the recommendations in the family report often encourage parties to settle rather than continuing to engage in costly and lengthy litigation. And whilst the court is not bound by the recommendations of a family report, they are normally pretty persuasive, and most people would rather resolve the matter following that than continue to have the court determine their parenting arrangements. So one judge recently told us that she was not listening parenting matters, non-urgent parenting matters, until at least 2021. And we know it's a bit of a tactic by Her Honour to encourage parties to settle, but unfortunately the delays in that particular court are extending all the time. So in terms of talking about how you fit into this process, the first topic I wanted to talk through was, what are your advice obligations? And do you have to tell the client what the Family Law Act says? The answer is basically no, unless you are an advisor. Now, an advisor under the Family Law Act are lawyers, family counsellors as defined in the Act, and we'll talk about that in a moment, and family dispute resolution practitioners, again as defined in the Act, or family consultant. So if you do fall into one of these categories as an advisor, you do have an obligation to provide advice regarding the children's best interest or child's best interest. That is to tell parents that you're dealing with that the child's best interests are the most important consideration, that the child's best interests be met by having a meaningful relationship with both parents while being protected from harm, and that being protected from harm is more important. In terms of obligations regarding parenting plans, those obligations are quite detailed and provide the obligation to give advice to parents about the options of having a parenting plan, the types of things that can be included, where the person can go for more advice about complying with or entering into a parenting plan, and also the issues of parental responsibility and the obligation to consider, if the parents have equal shared parental responsibility, an equal time arrangement or a substantial and significant time arrangement. So those obligations are quite detailed if you are an advisor as defined in the Act. The next issue then is, if you are an advisor, what are your notification obligations? Essentially, the Act says that you have an obligation to notify appropriate authorities if it is necessary to comply with the law of the Commonwealth, state or territory, and where a child has been abused or is at risk of abuse. The Act was amended in 2012, as I mentioned earlier, to expand the definition of abuse. So abuse includes assault, including sexual assault of a child, involving a child in sexual activity either directly or indirectly as a sexual object, serious psychological harm, including being subjected to or exposed to family violence, or serious neglect. In particular, that expanded definition to include exposure to family violence has quite a broad definition now, so it significantly expands what constitutes abuse and what needs to be reported. The issue of confidentiality, I can appreciate, is a key issue for many of you listening today, and the starting point really is non-confidentiality. Starting from a point of assuming that everything can be disclosed, everything can be subpoenaed, and everything is admissible. So for example, correspondence from GPs, psychologists, therapists, even if the participants treat them as confidential, can be non-confidential. So non-confidentiality is the starting point for you in terms of any sessions that you have with patients, clients, either as a counsellor or family dispute resolution practitioner. There are, of course, exceptions in the Act about whether material communications are confidential. So we'll talk about those. Those relate specifically to family counselling and family dispute resolution as defined in the Act. So what is family counselling? It is a process in which a family counsellor helps parties or children with issues relating to marriage, separation or divorce. Importantly, a family counsellor must be authorised in accordance with Section 10 C of the Family Law Act. There are 5 categories in Section 10 C, including, for example, complying with accreditation rules, etc. But in practice at the moment, there's actually only one of those categories that's capable of being fulfilled, and that is if a person is authorised to act on behalf of an organisation which is designated by the Minister. And there's a list on the Attorney General's website of the designated organisations. Sorry, the Federal Attorney General, I should have said. Those organisations designated by the Minister to provide family counselling include the well-known ones such as Relationships Australia, Centrecare, Uniting Care and Lifeline. So unless you are working for and are authorised by one of those organisations, you don't come within the definition of family counsellor for the purposes of the Act. You may be providing family counselling in the ordinary sense, but not family counselling as defined in the Act, and not as a family counsellor as defined in the Act. In terms of family dispute resolution, or FDR, similarly, it's a process in which an FDR practitioner assists the parties to resolve issues in relation to separation and divorce. Again, a family dispute resolution practitioner must be accredited under Section 10 G of the Act, and generally that means by complying with accreditation rules, completing the course, etc. As I mentioned earlier, family dispute resolution is compulsory before parents can proceed to court seeking parenting orders, unless one of the exemptions applies, family violence or urgency. So let's talk about confidentiality in those processes. Communications made during family counselling with a family counsellor as designated under Section 10 C by the Minister and or during family dispute resolution are confidential and inadmissible unless an exemption applies. And that you can see sections 10 D, 10 E, 10 I for the Act in relation to those issues. Essentially what Section 10 D says, and sorry, 10 I says, is that family counsellors as defined and FDR practitioners must not disclose the communication made in family counselling or FDR, but they must disclose to comply with the law, that is, reporting abuse of a child. And they also may disclose, if their patients or clients consent, if the disclosure seems necessary to protect a child from harm or report an offence or to assist the independent children's lawyer. Excuse me. It is really important to note that there is a distinction between communications that may be disclosed and the admissibility of those communications. Admissibility is whether those communications will be admitted into evidence before the court. Communications made during a family counselling and or family dispute resolution process are not admissible unless there has been abuse or there is a risk of abuse. So what that means is that communications that may be disclosed, for example, if all parties consent or to help the ICL, are still not admissible in court proceedings. Essentially, Section 10 E and 10 J say that evidence of things said with a family counsellor or FDR practitioner conducting family counselling or FDR are confidential and not admissible. However, the exemption is there's an exemption that applies where there has been an adult's admission of child abuse or child's discussion of abuse, unless the court thinks there is sufficient other evidence before it in relation to that admission or disclosure. So now I just wanted to talk through a few cases which puts all of this into context. The most important one probably is the Uniting Care Unifam case. And this was a case where one of the parties had subpoenaed the counselling notes from a family counselling process with Uniting Care. The court had in fact made an order that Uniting Care should produce those documents, and it went to appeal. The appeal court said that the wording of Section 10 D(3) means that the discretion remains with the family counsellor whether to disclose, even if the parents consent or the court directs. Section 10 D says that there are some categories where a counsellor may disclose, including when the court directs or the parents consent. This case determined that it's still up to the family counsellor, even if the parents have consented, or the court directs whether or not to disclose that communication. Again, it's important to note that even if the communication can be disclosed, it is still not admissible in the court proceedings unless it relates to abuse or risk of a child. Another case that's important on this issue was the 2013 BADEN-CLAY case. That decision, as it relates to family counselling, confidentiality and admissibility, essentially involved a family counsellor from whom the police sought to obtain evidence to use in the murder trial. The Supreme Court held that Section 10(d) and 10(e) of the Family Law Act, which says that communications during family counselling and FDR are confidential and can't be admitted into court, only applies to courts which are exercising family law jurisdiction by virtue of the Family Law Act. So the court decided that the application of sections 10(d) and 10(e) is limited to courts exercising power provided to them by the Family Law Act. The court in the BADEN-CLAY case was a court exercising criminal jurisdiction and not exercising any jurisdiction under the Family Law Act. Therefore, the inadmissibility provided by those sections 10(d) and 10(e) did not apply. That decision has possibly wide-ranging implications for other non-family law matters, including in the domestic violence circumstances, which operate at a state-based level rather than the federal jurisdiction. Interestingly, in relation to the domestic violence aspect, the Family Law Act says that if there is a domestic violence order between the parties, that needs to be disclosed to the court, as do the circumstances upon which the order was made, including the evidence which was relied upon in the making of the domestic violence order. So I haven't heard of a case yet in relation to this, but I expect it will come where the fact of a domestic violence order needs to be disclosed to the court, and do the circumstances and evidence upon which that order was made, essentially by the route of the domestic violence proceedings. So prior to the BADEN-CLAY decision, this issue was flagged as an issue which needed revisiting, and the Australian Law Reform Commission's report, Family Violence, A National Legal Response, in 2010, I think, at recommendation 22.4, made mention of this. However, there's been no amendment to date. So stay tuned on that issue. And interestingly, in the BADEN-CLAY case, just as a note of interest, the counsellor raised as a basis for the inadmissibility of the notes an argument that the public needed to have confidence in the confidentiality of the counselling process, because knowing that counselling was confidential encouraged people to engage in the counselling process. The court, however, said in that case that confidence was outweighed by the public interest of having all possible evidence available to the court in determining the most serious of offences, being murder. So there have been a few cases which have dealt specifically with parenting plans, and I wanted to talk through some here. It's important to note that a valid parenting plan that is signed and dated and made free from duress at the conclusion of a family dispute resolution process is admissible and not confidential, even though it is made during the FDR process. Obviously, it would defeat the purpose of engaging in the FDR process if the agreement you reached at the end of it could not be later relied upon. However, an agreement reached at family dispute resolution will be inadmissible unless it is properly documented as a parenting plan. So it needs to be signed, dated and entered or made free from duress. So unless it meets those criteria, it will not be considered a parenting plan, and it's just a document prepared in the FDR process. It's not admissible. Interestingly, a recent case dealt with a situation where there was what appeared to be a validly signed parenting plan made during the FDR process, but the father alleged that it was actually made under duress. The court held that any evidence from the FDR process which would tell the court whether there was duress was actually inadmissible. So the court was stuck in an unusual situation where they couldn't take any evidence about the process involved in reaching that parenting plan, and it appeared on the face of it to be a valid parenting plan, but the court had to find, because there had been no evidence from the FDR process regarding duress, they couldn't conclude whether or not the parenting plan was made free from duress, so it wasn't a parenting plan. Another interesting point that's come up in a few cases is, what is family dispute resolution? When does it start? When does it end? And therefore, what parts of it are confidential? There are two cases which are completely conflicting on this issue and don't appear to refer to the other. This is certainly an area which needs further court determination. And the first one is Raster and Ball, which is a 2010 case. And it basically said that the FDR is a two-stage process because the family dispute resolution practitioner is required to undertake an assessment at the commencement to assess the party's suitability to undertake the FDR process at all. What they said is that the assessment process is therefore separate to the actual FDR process, so that assessment process is not confidential. The parties had all agreed to attend FDR, the court had directed them to attend FDR, and then it was Centrecare in that case who had conducted almost 7 hours worth of sessions with the parties and come to the conclusion that it was not suitable for FDR because it was unlikely to resolve the matter. The court in that particular case obviously wanted to know why. If the court had thought FDR was appropriate and the parties were agreeing to FDR, Centrecare had decided it wasn't appropriate. So in that case, it was ordered that the assessment process notes were not confidential and could be admitted to the court. The other case is French and Winter, which is a 2012 Brisbane case. And in that case, the mother attended upon an FDR practitioner, although she attended for the purpose of counselling. The practitioner, however, said, I don't do counselling anymore, I only do FDR. The mother attends alone for 4 days before a final hearing, and she said it was to help her focus on the needs of her children. So in no way was she seeking the family dispute resolution process. However, what the court decided in that case was that if the FDR practitioner thought that's what they were doing, and even if it was a one-off session, that could be part of the process that begins with one session of one party for engagement with the other party. That could all be part of the FDR process, and all the FDR process is confidential. So those cases are completely conflicting, and just like most of the aspects of these confidentiality provisions, they haven't been properly tested before the courts, which leaves a lot of uncertainty for all of us about how and when communications will be confidential and what does and doesn't form part of family counselling and FDR. So again, talking about the family counselling process and what does and doesn't form part of that, it's really important to remember that the confidentiality provisions only apply to people who are accredited family counsellors as per section 10 capital C, i.e. working for an organisation that's been designated by the minister. Otherwise, the family counselling confidentiality provisions do not apply. And even where they are working for organisations that are designated, the counselling still needs to meet the criteria of family counselling as defined in the Act. In one case, the court basically said that meetings between a child and a school counsellor did not come within the definition of family counselling in the Act, and therefore the confidentiality and inadmissibility provisions do not apply to that type of counselling, notwithstanding the claim made by the Director of Counselling and Family Services at the particular agency that it was designated by the Minister pursuant to section 10 capital C. The counsellor was not providing counselling related to the marriage relationship or the interpersonal relationships of the parents and all the effects of the breakdown of the relationship. The parties have been separated for more than 5 years, and the issues between them did not have anything to do with the quality of care each of them provided to the child. Another case involved a process where the child and the parents were undergoing attachment therapy. And the court said that unless we know what attachment therapy is, as distinct and discrete from family counselling, or it is clearly family counselling, then it's not family counselling pursuant to the Act, and that attachment theory process was therefore found to not be confidential and could be admitted into court proceedings. So I just wanted to quickly touch on the issue of whether you can be required to give evidence before a court. As you've no doubt gleaned from this presentation, the answer is yes, and the way that is normally done is through a subpoena. Subpoenas can be issued from any courts exercising family law jurisdiction or other jurisdictions, such as in domestic violence matters. And a subpoena can be either for you to produce documents or attend to give verbal evidence to the court. Another option is that you might be asked by a parent or by their legal representatives to provide a letter or report about the client attendances upon you. And if that is admitted into court, then it usually needs to be attached to an affidavit sworn by you and submitted to the court to be able to be relied upon. Subpoenas compel you to give evidence. The court directs you to give evidence, so you must produce documents or attend court to give verbal evidence. There are penalties if you don't comply. There's some limited grounds upon which you can object to the subpoena. For example, if the information requested is irrelevant or it's too broad in its scope. You're entitled to be paid conduct money for producing those documents to the court, and you can also request that your costs of having to attend court be reimbursed to you. My suggestion would be that it's always prudent to inform your client that you've been subpoenaed, and also for yourself to seek independent legal advice prior to just producing those documents. Even though it's likely that if the subpoena is properly prepared and properly issued to you, you'll have to produce those documents, it's always prudent to get some advice about that before just posting them off to the court. And my understanding is that many of your professional indemnity insurers will often be able to provide you or put you in touch with someone who can provide you with legal advice about producing those documents. And it's important to note that your client will be aware if your material has been subpoenaed, and they will also have the opportunity to object to the subpoenaed documents being sought. So legislation has recently been enacted in Queensland, which prevents counselling records of victims of sexual assault or alleged sexual assault from being sought and relied upon in proceedings in some Queensland state courts. The legislation does not apply in the family law jurisdiction, which is a Commonwealth jurisdiction. The court proceedings covered by the legislation, the most recent legislation, are criminal and civil court proceedings commenced on or after 1 December 2017, which includes domestic violence proceedings. The Counselling Notes Protect service, which is facilitated by Women's Legal Service, provides free legal advice and representations to individuals who may need to rely on this legislation. So consider referring any clients whom you believe this legislation may apply to Women's Legal Service Queensland for advice and support. Counselling under the Counselling Protect legislation is considered broadly, including when a counsellor, which may include a doctor, listens, gives support, provides help or encouragement, advises and/or gives therapy or treatment, including group therapy. Counselling records will be protected by this legislation from being available during a court case or from being subpoenaed for a court case. Counselling notes are not protected by this legislation prior to any court proceedings being commenced, for example, where the police are still investigating a matter. And if a party is seeking a record of counselling of this kind in a proceeding for a trial, sentencing and/or domestic violence order matter, protected counselling communications has qualified privilege and material can only be provided to the court with leave of the court. In a recent family law case, a child psychologist objected to a subpoena issued to her. The court had made orders that the parents and child attend upon the psychologist. The child and father were attending upon the psychologist for the purpose of repairing a relationship between the child and the mother. It was the mother who issued the subpoena. The psychologist gave evidence and was cross-examined as to the impact upon the child of access to the subpoenaed material. The key impacts identified by the court upon the child should access be granted to the subpoenaed notes were that it is potentially destabilising of the child, undermines her current therapeutic relationship, and potentially her capacity to develop future therapeutic relationships in the context of, again, potentially needing them given the issues that the child has faced. While the obtaining of information from the psychologist had the potential adverse consequences identified in her evidence, relevant information was and is the prerequisite for determining what is in a child's best interests. There was good reason to consider that the information obtained in the therapeutic process has the potential to be decisive on the ultimate question of what was in the child's best interests. This weighed in favour of granting access to the psychologist's notes, both because of the public interest and interests of the child to have a decision made in her best interests. That access was conditional, however, being limited to use with a therapist or potential family report writer. So now turning to affidavits. If you're voluntarily producing something like a report for a client, it may well end up being used in the court process. As I mentioned, a report normally must be attached to an affidavit, which the solicitor would prepare, and that affidavit would say something like, I'm a counsellor working for X. I've been asked to prepare a report, a copy of my report's attached, and I believe it's true and accurate to the best of my knowledge. If you produce an affidavit like that to the court, you should be aware that you could be called to give evidence at a trial and be cross-examined on that evidence and the content of that report. So really, to summarise, it's important to know that the default position is non-confidentiality. The interpretation of the confidentiality and admissibility provisions in the Family Law Act is still quite unclear, and there are many exemptions which can apply. So you should really assume your notes can be subpoenaed and you can be compelled to give verbal evidence. Obviously, there are exemptions that apply, but that's not always a possibility. So you should bear this in mind when you're dealing with clients and keeping any notes you may decide to keep. So really, thank you all for your attendance today out there in webinar land. And if you do have any questions on topics that I've been talking through today, I'm more than happy to receive those by email at the email address on the screen. And if you do have any more specific topics that you're interested in us discussing with you, we can always come to you. So please don't hesitate to contact us in relation to us doing that. And I'm sorry, I'm just looking and I might see a question down here. It's probably better that that you'd email those to me. The answers to these can be quite extensive, so I'm more than happy for you to email that question directly to the email address on screen, and I'm probably, no doubt, knowing me, will pick up the phone and give you a call to discuss. So really, following on from this webinar today, you'll be emailed a feedback survey, and we really appreciate any feedback that you can provide to continue to improve this webinar process. So thank you all again for today, and please keep the email questions coming. Thank you.